Hello and welcome to Rights of the Free People, a program of the Rhode Island affiliate of the American Civil Liberties Union. I'm Dan Weissman, a volunteer at the ACLU and host of our program. If you look at the calendar, it says August. That means we're doing the Supreme Court this month. It's an annual event in the ACLU calendar. And we have two people who probably know more about the Supreme Court than maybe we'd want to know. And we're going to find out some of the civil liberties cases that came up this year. And if time permits, we'll look into what might be coming up next year. So I'll introduce our guests. Starting closest to me is Jared Goldstein, a professor of law at Roger Williams, and a cooperating attorney of the Rhode Island affiliate of the ACLU, and a rookie on this show, first time. Jared, I hope we will see more of you as we do more programs.
Well, thank you for inviting me onto the show.
My pleasure. And another rookie, two rookies, and both lawyers. And Antonio Massa Viana, who came all the way from Framingham, Mass. To join us today. He is a ACLU board member in Massachusetts, our loss. And there's a little kind of background story to today. It turns out that our two guests are old friends and had a bit of a reunion in our green room. So let's start with Antonio, because I think you had the bigger reaction when we introduced ourselves about a half hour ago.
Well,
what's
Dan,
the story?
Thank you so much for having me. And you know, you don't know me yet, but I have lots of big reactions, right? So Jared Goldstein was my professor at law school, and I loved, you know, seeing him and bumping into him. This was an amazing surprise for me. Not only he introduced me to constitutional law and drilled me in class on a few occasions. You know, we've been through a lot together. Law review.
Oh yeah, Antonio was a star student of mine. He took constitutional law with me. He took First Amendment law with me. He was the editor-in-chief of our law review. And then, I mean, probably our most important work together was when Antonio tried to become a member of the Rhode Island Bar. There was some obstacles. You want to tell what the?
Yeah, sure.
This is a good lead into some of our conversation.
Sure, absolutely. And so although I've been living in the United States since I was 12 years old, for a lot of that time I was not lawfully present in the United States, so I had no legal immigration status. And it was my experience having no legal immigration status and working with other people as an organizer that had no legal immigration status that really drove me through law school. I went through 3 years of law school without status, and when it was time to take the bar, people were a little reluctant to say, you know what, yeah, go for it, because they're like, well, you know, you don't have status, why should you really take the bar and become an attorney? But this was something I really wanted to do. And I took the bar in both Massachusetts and Rhode Island. In Rhode Island at the time, to sit for the bar, we had to write a special petition to the Supreme Court, which we talked about for many hours, right? Mm-hmm. And we discussed the arguments until we finally decided, not only with counsel from Professor Goldstein at the time, but other professors at the law school, to file the petitioning to sit for the bar in the Rhode Island Supreme Court did allow me to sit for the bar. They did not grant me my license, though, until I was able to receive legal resident status. But Massachusetts, on the other hand, 6 months after I took the bar and passed, did give me a license. So I became an attorney before I became a legal resident of the United States. And you know, the irony is that I would go into immigration court every day to defend people who had no legal status, and I had no legal status.
Right. So Antonio's work as an immigration lawyer comes out of his own personal experience, but also educated, you know, by me and by my colleagues at the law school,
Absolutely.
you know, where he, you know, excelled.
Absolutely. I mean, I can say that I'm incredibly proud to have attended Roger Williams and to have met the amazing professors that I met there. And you know, he knows I took every one of his classes, so he certainly knows that he's up there as one of my favorite professors.
Oh, thank you.
So it's a privilege to have both of you here. I don't know what took so long, since you've both been around, and we've been doing this program for years, and you're both involved with ACLU. So let's get into it, and we'll see how much the professor and the student have learned over the last few years. We're going to look at two categories of cases of particular interest from the Supreme Court, most recent session, of particular interest to civil libertarians. One category is First Amendment cases, and we have 3 that were judged this year, and then we're going to look at 4 immigration cases. Time permitting, we'll look at 2 cases that we expect will come up next year. So Jared will be our First Amendment person, Antonio will be our immigration person, but we'll go back and forth and help each other make sense of this. So the first case in the First Amendment cases is Mattel v. Tam. And this is a tough one as I read this, because to me it was offensive. So tell us the story.
Yeah, so the Mattel versus Tam is a case about a rock band called the Slants, who are Asian Americans and who chose the name the Slants, I think, even though it was a disparaging term for Asians, as a way to reclaim the name. It's sort of an ironic name. The legal issue arose when they tried to register the name through the Patent and Trademark Office. They tried to trademark the name the Slants, but the Patent and Trademark law prohibits the registration of trademarks that are disparaging to any person or group of people. So the Trademark Office said no to the Slants because they found the term disparaging. They appealed ultimately up to the Supreme Court, which held that the disparagement statute, the statute that prohibits trademarking any disparaging term, was unconstitutional under the free speech clause of the First Amendment. It was an interesting issue in a lot of ways. I mean, normally we think of the free speech clause prohibiting the government from restricting speech. And in a certain way, the Patent and Trademark Law doesn't restrict anyone's speech. That is, the Slants were free to call themselves the Slants whether they trademarked their name or not. They could call themselves the Slants if they wanted to. What they couldn't do under the law that they were challenging was get the special legal benefit of having a trademarked name. The way that, if the company that makes Tide detergent has a trademark on the name Tide. No one else can call themselves Tide detergent, so that consumers will know what they're getting when they buy that product. Once you trademark the name the Slants, no other band can call themselves that. And so that was what was at issue. Can the government say no to a trademark because the name is offensive or disparaging? It's the same issue that comes up with the Washington Redskins. That name of that NFL team is trademarked, and the Redskins team makes a lot of money selling jerseys because they have trademarked the name and the logo of the Redskins. But a lot of people have challenged it. Native Americans have challenged it because it's an offensive term, and they don't want the government's imprimatur that is approving and giving special status to offensive terms. So that was the issue before the court, and the court said that the law was unconstitutional because the government couldn't say no to a trademark claim because of the offensiveness of the idea. That is, it was what the court called was viewpoint discrimination. It was that is, if they said something nice about Asians, they could trademark the name. If they chose Up With Asians for their band name, they would have had no trouble getting the name trademarked. But if they say something that was perceived as disparaging, like the Slants, they couldn't get it trademarked. And the court said that violates our core principle in First Amendment law against discrimination based on viewpoint. So that was the crux of the decision.
Do you think that because, that is also a restriction of speech, because obviously by not trademarking some certain terms, then you don't allow, for example, a band who's also a commercial enterprise to profit from those terms. So in a way, you're also restricting speech in that sense, right? Or now?
Yeah, that is, they were always free to call themselves the Slants. They just didn't get the commercial benefit of saying to another band that wanted to call them, we're the Slants, you're not the Slants. In a certain way, there's like an irony to the case, because trademark law is about restricting speech. That is, if I make Tide product, I can tell you that you can't. You can't put a Tide on your box. You can't put Coca-Cola on your can. Trademark and patent laws are about restricting speech. That is, it's saying I have a monopoly on that logo and those terms. So in a way, by protecting their right to call themselves the slant, they restrict other people's right to call themselves that. But the court says that may be, but the reason why they're saying no to it is because of the offensiveness of the idea. There may be other reasons why you could restrict trademarks, if it was confusing to consumers or the like, but you couldn't say no to them for this reason. And that was so it wasn't even so much that the trademark was itself speech, but you couldn't say no to them for a reason that violates our free speech principles. That is, that the government shouldn't be conditioning a benefit based on the offensiveness of an idea, so that some people get protection and other people don't if what they're saying is offensive.
Interesting.
Let's move to sex offenders.
Oh, yeah.
Oh, yeah, another one. And social media websites. Jared, what was
yeah,
that
so
case?
this is a case called Packingham versus North Carolina. North Carolina had imposed a felony statute, made it a crime for registered sex offenders to access or post anything on social media. So it was Facebook, Twitter, Instagram, any social media website that allows people to post text or pictures or have access by a lot of different people. The idea of it was that sex offenders might use social media platforms like Facebook to facilitate assaults of minors. They might find potential victims online. They might lure them into dangerous situations online. So they wanted to prohibit sex offenders from having access to social media because they might use it in this way to facilitate a crime. The problem is it prohibited them from accessing social media for any purpose. That is, they couldn't post a cat video on Facebook. And the challenger in the case, who was found to have committed a felony, was a sex offender who went on Facebook and posted, God is great, because he had gotten out of a parking ticket. There was no facilitating of a crime other than celebrating his, getting out of the parking ticket through his Facebook post. And so the court said, and this was like Mattal versus Tam, was a unanimous decision. The court said the law is overly broad. That is, the government can't restrict speech or access to speech, even for very good purposes like preventing sex crimes or sexual assaults of minors, unless it's narrowly tailored. And this statute was so broad that it prevented a class of people from getting access to any speech for any purpose, because sometimes they might use it for an illicit or a wrongful purpose. So it was a statute that was trying to address a very serious problem, but in a way that restricted a very large amount of speech. The court suggested that they might be able to write a more narrowly tailored statute that prohibited using social media for facilitating sexual assault, but they couldn't prohibit a broad class of people from getting access to this very important medium.
So we have two ACLU wins. Now we'll go to one that's not so much, and that's Trinity Lutheran.
Yes. Yeah, now this one isn't a free speech case. This is a religion case. It's
still First Amendment.
It's still First, oh sure. Yeah. It falls under the First Amendment, but it's a different clause. Actually, a pair of clauses. Trinity Lutheran is a case about a Missouri statute where they gave grants to playgrounds and schools to get money for rubber surfaces for their playgrounds. And under the Missouri statute, anyone could apply to get this money, except for churches.
According to their constitution.
Yeah, because Missouri has a constitutional provision that no state funds should go to support any religion. And so a daycare could get money, or private school or a public school could get this money for this rubber surface for their playgrounds, but the Trinity Lutheran Church could not, because Missouri had made a decision a century ago that no state funds should go to religious purposes. But the Trinity Lutheran Church believed that this was religious discrimination. That is, that they were being singled out for different treatment because they were a church. That is, if they were a nonprofit, a secular nonprofit, they could get the money and they could protect their playground and their kids wouldn't have to get skid knees. But the only reason why the kids get skid knees on the Trinity Lutheran Church playground is because it's a church. And they said that's religious discrimination. And the court, by a vote of 7 to 2, agreed with the church and said, if you make money available for this program, generally, you can't single out religious groups for different treatment. It would be like, from the court's point of view, if you make available a service like, fire protection or police protection or garbage pickup and said, we're not going to protect churches. We're going to let the church burn down, even though we would put the fire out at their neighbors. And the court said, you can't single out a church for different treatment like that. But Justice Sotomayor and Justice Ginsburg dissented because they said, now the court is saying that the state of Missouri has to give money to a church, even though it doesn't want to. It thinks that it would violate its understanding of the Establishment Clause for the state to use money to directly fund this religious organization, carrying out what it considers its religious mission, which was included providing a daycare. And they thought this crossed a line for them that the government should not be funding a religious organization.
What's your personal opinion on that? I mean, when you look at this, do you think that the court got to the right answer? Or?
I disagree with the court. I agree with the dissenters in the case. I mean, I do think it's complicated. And the court has made it complicated, but you have a clash of two different constitutional provisions. That is, you do have an Establishment Clause principle that says the government shouldn't be supporting religions, shouldn't be, and especially shouldn't be funding religion. But on the other hand, you have the Free Exercise Clause, which says the government shouldn't be discriminating against religion. And so it was a case that could fall on either side of it, but the court has made it. It used to be that there was a bright line rule, no funding. But then, in a series of cases, the court has made it so that the government first can fund religious organizations. For instance, in school voucher
there were the
type
school
cases.
voucher cases, right, where the government was allowed to fund.
Sure.
And then that was taken away.
Right. Well, no, that's still good law. So that you can give money. At least you can give money to parents to use in private schools, and you can give other services to religious schools. For instance, if you were giving away textbooks, you could make that available to churches and to secular schools. In all those cases, the government was deciding that they wanted to do that, right? So the question was, does the Establishment Clause stop them? But here was the opposite, where the state says, we don't want to fund churches because we think it violates our idea of separation of church and state, and the court says you have to. That's a very different proposition than saying the state can give a school voucher program. This sounds like the government has to provide a school vouchers. If they're making it available for secular schools, they have to make it available for religious schools too.
I guess the answer here is to look at the funding. It's the activity that's being funded, right? Because in this case, it's the actual playground.
Yes.
So it's not the church. And when you talk about playgrounds, why are you going to discriminate against the church who's providing that playground?
That was the prevailing
school.
Sure, and that was one of the things that they fought about. There was that is, if they said all your funding is like the secular action of the church having a playground, that is, the swing set on the Trinity Lutheran Church is just like a swing set on any private or a public park. That's not part of their religious activities. Although the church always said, the daycare that the playground is part of is part of their religious mission. And also, if you fund the playground, then they can use the money that they would go for the playground to pay for the pastor. That is, since money is fungible.
So I get to interrupt two lawyers.
Yeah.
This is like the height of my career here, because we're running out of time, and we need to cover the immigration cases. So, boy, that was like a thrill.
See, you can see why he got such a good grade in my class.
I know. Maybe I
just
should
the
have
right
chose law.
questions.
Let's talk about the travel ban.
The travel ban.
And that's International Refugee Assistance v. Trump.
Exciting. So the travel ban is a case that got to the Supreme Court, and it basically was an injunction. The Supreme Court stayed the injunction of several cases in the district court and circuit courts around the United States, based on the series of travel bans that were issued by the government after President Trump came into power. And basically what the travel ban said, amongst other things, is that it was putting a stop on the entry of refugees into the country, and putting a stop on the issuance of visa from people from 7 Muslim majority countries, which on the second version of the travel ban became 6, because they decided to exempt Iraq after it became politically non-palatable for the administration. So, but basically the administration argument is we cannot vouch for these people. We're not sure that the people coming in are not going to present a danger to the United States. So we need to stop the process on its wheels right now, look at our procedures and issuing those visas, and then within 90 days we're going to issue these processes again. The problem is, during his campaign, President Trump talked a lot about a Muslim ban, right? Which we were just coming from a discussion on the Establishment Clause, right? And the Free Exercise Clause. The government should have no business deciding who comes in or into the country based on their religious choice. And because of those statements, and also because of a section in the first executive order that stated that the government should be able to make it easier for people in Muslim countries who are Christian minorities to come in. So there was an exception on the first executive order. Several courts across the U.S., if I'm not mistaken, Hawaii was the very first court, basically issued the national injunction saying, you know what, the government cannot, and enjoined the government from proceeding and enforcing the order. The case that went up to the Supreme Court, and in theory, the Supreme Court said that, well, actually, the Supreme Court, it cut the baby in half. What the Supreme Court said was, for people who have ties to the U.S., either familial ties or ties to maybe an organization, like a student who has been studying in the U.S., or a refugee who has been going through the whole process, this order is active, right? So it's not enjoined. But the orders stayed in regards to people who have no substantial ties to the U.S. So maybe somebody who just wants to come to the U.S. from one of these countries to visit the U.S., does not have family in here. So those people, the government can basically say, wait a minute, we're going to keep you out until we review our procedures. I don't think it's, although the government has gone on TV to say that this was a win for the government, I don't think this is a real win. I think this is a real win for the people who have ties to the U.S. and were able to establish that it would create an undue hardship for them to, if they were not able to come in. So I think the government lost here. Now, we were discussing whether they are ever going to get to the merits of this case, because the injunction, I mean, the 90-day period is going to be over at some point before they actually tackle the merits.
Right. I mean, the court is scheduled to hear the case in October, but the order that is being reviewed will have expired by then. So I think that the court set it up so that they will not actually have to reach the merits. But the merits are very interesting, just to mention them, because the central issue is, is the order an expression of anti-Muslim bias? That is does it discriminate against people because they're Muslim? The word Muslim or religion doesn't appear in the order, but it excludes people from Muslim majority countries. from a president who campaigned on a Muslim ban and who then asked his advisors, including Rudy Giuliani, how could we go about implementing the Muslim ban? And they came up with this plan so that it was by countries, Muslim majority countries, without ever using the term Muslim. But there's a vast amount of evidence that the purpose of the ban was to keep out this category of people, Muslims, because the administration thinks that they, as a class, pose a danger to the country. And if that's right, that is, the question is, can the government exclude people because of religion from entering the country, or does that violate the Establishment Clause? And all the courts that have looked at it said that that would be a violation of the Establishment Clause.
Yeah, and it's interesting because the State Department could have simply done this a different way, right? They have the power to exclude people and not grant visas outside if they decide for one reason or the other, for example, that the person is going to come and reside in the United States. So I think they just went about it in a very budget way. So
In a very
bad way. I mean, the strategy was just horrible. I mean, if somebody's arguing for the government, if somebody is counseling President Trump on this, I mean, it was just bad counsel.
Well, right. I mean, it was clear it was issued without review by Homeland Security, by the State Department, even by the Office of Legal Counsel within the Justice Department gave it a green light only as for form, but without any investigation of its content.
The first order was stopping residents, legal permanent residents, from coming into the country.
Right, and people who had been issued visas were stopped. When they landed, were sent back. It created chaos.
We know sports teams were not allowed to come in and compete in events that they had been invited to come into.
Yeah. I mean, it caused immense amount of chaos. But I think this is an example where you see the power not just of the lawyers like us working through the courts, but what happens when you have an engaged public. Because when that order was issued, people swarmed to airports and protested, and there was just mass amount of activity about and around the travel ban that I think really helped keep a focus on it and made got the court's attention and made the administration back down. So we in law school we often pretend as if what matters only is what happens in courts and among lawyers, and not what happens out on the streets and what happens with public opinion. And this is a case where public opinion made a big difference.
So time is running by, and I've got a couple that we want to try to cover about a minute apiece. Okay. So let's do Ziegler, the Abazi.
Yeah. So Ziegler v. Abazi. It was the case of a Bivens action, right?
Yes.
Against, there's a set of people who were detained right after the attacks of September 11th. They were detained in a Brooklyn detention center, and they accused the government of violation of their civil rights, violation of the Fourth Amendment, because they were patted down all the time and brought in, stripped down. They went through several strip searches, and also they were kept in detention for times at end without bond hearings.
Why were they prisoners in the first place?
Well, most of them were unlawfully in the country.
Okay.
They were Muslims, and
sorry to interrupt. Yeah. There was a sweep of people after 9/11, where they rounded up Muslims who they were suspicious of, but it was, it was a broad violation of civil liberties directed at the Muslim population.
Muslim community.
Yeah, and then once they were detained, they were, mistreated. And so then they brought a claim of constitutional violations against the government based on this treatment, and that was what the case was about.
Right. And what the court decided in that case is that the detainees, who are no longer detainees, many of these people have been removed from the U.S., that they did not have an action against the officers who abused them. But for one issue, there is one issue that they remanded down to the circuit court, which is the issue of whether this particular officer who allowed other officers to abuse the prisoners actually is immune and is liable. There are also issues of Fourth and Fifth Amendment violations that the court did not reach. Am I correct in this?
Right. Well, I mean, part of the
Because-
effect of saying that they have no Bivens claim, that is, which is a suit against the government for constitutional violations, so you don't get to decide whether there was
What
a
the
violation
Constitution's right.
in the first place. It's a case that makes it much harder to sue the federal government for constitutional violations, unfortunately. in my
Which
opinion.
was never easy, right? I mean, these cases are very limited in
Right.
its reach. I mean, I think
Right.
we have like 2 or 3 Supreme Court cases.
Right.
And
They've
this
been
is-
making it harder and harder.
And there's an immigration detention case coming up next year.
There is. That's Janice v. Rodriguez. And this case is important because today what happens is a lot of immigrants, a violation of immigration law is a civil violation. And a lot of immigrants today, they sometimes are detained indefinitely, for 6 months, a year, sometimes 5 years, without being able to seek release from court. So this case comes in a series, there's been a series of other cases in the Supreme Court that basically talks about whether these people are allowed to petition for a bond hearing, which would grant them some liberty, will allow them to wait for the resolution of their cases in liberty. And this is another one of those cases. The first one was Adivias in 2001, which basically said if you can't deport this person because this person is stateless, you've got to let this person go, or at least provide this person with a bond hearing.
And they're sharpening the hook to just whisk the three of us off because the studio goes to somebody else. That was quick, and we didn't get to all the cases. Maybe our producer will let us do another program later in the year. But I've got to thank you both. This has been fascinating. We have 2 now former rookies. And so let me thank you, Jared Goldstein from Roger Williams and one of our attorneys. Thanks. This has been fantastic. And Antonio, I lost it. Oh, there, Massa Viana from Framingham, and a board member for the Massachusetts ACLU. Thanks so much for being here. It's been a pleasure. If any of these issues are of interest or concern, our contact information is on the screen. Thanks for tuning in. We'll see you next time.